The documents did not surface all at once. They arrived in fragments, redacted pages, delayed disclosures, file numbers without files attached. What federal officials described as administrative backlog looked on paper like something else entirely, a system straining to keep certain facts out of public view while insisting nothing was being withheld. By the time internal counts quietly crossed the four-digit mark, the number alone raised a question that no press conference ever answered. If more than 1,000 individuals were identified as potential victims inside federal records, why had so few cases ever reached a courtroom? And who decided where the line of exposure would stop? Inside, sealed logs reviewed by congressional staff, victim identifiers appeared without corresponding investigative outcomes, names replaced by initials, dates replaced by black bars. In multiple instances, intake reports were marked credible, yet routed nowhere. No referral, no follow-up, no explanation. The silence was procedural, not accidental. At the same time, a separate evidentiary stream moved in the opposite direction. Photographs, long rumored, rarely acknowledged, were logged, cataloged, and then quietly restricted. Images tied to high-level social encounters, guest lists that overlapped with diplomatic travel schedules, visual records that, according to internal memos, required special handling due to sensitivity. Among those images were photographs involving Bill Clinton, taken during periods when his official movements were otherwise accounted for only in partial form. The photos themselves were not alleged to show criminal conduct. That distinction mattered, but their existence raised a different issue entirely: why evidence connected to a former president was segregated from standard evidentiary review in a case supposedly governed by equal application of the law. Career staff raised concerns. Those concerns were logged, then they stalled. Emails reviewed later showed repeated requests for guidance sent up the chain and returned with vague instructions to stand by. In one instance, an investigator asked whether certain materials should be shared with a parallel inquiry. The response came days later: hold pending further review. No review date was assigned. Oversight committees would later ask what had been known and when. The answers shifted. First, officials said the scope was unclear. Then they said it was understood but sensitive. Later still, they said disclosure might interfere with ongoing matters, despite no active prosecutions being named. Throughout this period, the Department of Justice maintained that its handling of the case followed established protocol, but protocol typically produces paper trails. Here, the trail kept disappearing. One internal index referenced more than 1,200 victim files. Fewer than a fraction were ever summarized for external review. Entire sequences of file numbers were missing. When asked directly about the discrepancy, department representatives did not deny it. They reframed it, citing privacy protections and jurisdictional limits. Yet privacy does not normally erase case existence. Jurisdiction does not normally dissolve evidence custody. So the question for any reasonable reviewer became unavoidable. Who benefited from delay? Because delay was not passive. Each year that passed narrowed statutes, scattered witnesses, and dulled public attention. Each redaction created distance between the record and accountability. Each withheld photograph reduced the likelihood that power would ever be forced to explain itself. No court order required that outcome. No judge signed off on mass inaction. These decisions occurred earlier, quieter, inside conference rooms and email threads that never made it into public filings. And as these files expanded in volume but not in consequence, the gap between what was documented and what was pursued continued to widen, leaving behind a record that suggested not a lack of evidence, but a surplus of restraint applied in very specific directions. The restraint did not originate at the investigative level. Field agents continued to submit memoranda noting inconsistencies between witness accounts and the official narrative that had already been settled in public. Several flagged travel overlaps. Others noted recurring names appearing across unrelated intake forms. Each memo carried the same closing line: further guidance requested. That guidance rarely arrived. Instead, control shifted upward. Case coordination was reassigned. Access permissions changed. Systems that once allowed cross-referencing between agencies were narrowed under the justification of need to know. In practice, that meant fewer people could see the full picture, even as more pieces of that picture continued to surface. When the Federal Bureau of Investigation conducted internal audits of evidence handling, discrepancies emerged almost immediately. Digital logs showed files accessed without corresponding case notes. Physical evidence inventories listed items that could not be located. In at least one review, auditors noted that entire folders appeared to have been reclassified after initial intake, moving them outside routine discovery obligations. Reclassification is not illegal, but it is consequential. Once material is designated administratively sensitive, it enters a different procedural universe, one governed less by courts and more by discretion. Who exercised that discretion and under what authority was never clearly answered. At the same time, parallel inquiries inside United States Congress began asking narrow questions. How many victims were identified? How many cases were opened? How many referrals were made to prosecutors? The responses came back technically accurate and substantively hollow. Numbers without context, totals without timelines, assurances without documentation. One committee staffer later described the briefings as carefully incomplete, not false, not transparent, designed to satisfy oversight requirements while revealing as little as possible about decision-making at the top. The issue of the photographs resurfaced during these exchanges. Members asked whether any visual evidence involved current or former public officials. The answer was framed cautiously. Officials said no images had been substantiated as criminal. That was true. But it was also beside the point. Evidentiary relevance does not depend on criminality alone. It depends on corroboration, pattern, and credibility. Those questions went unanswered. Behind closed doors, attorneys debated exposure risk, not exposure to defendants, but exposure to institutions. Internal legal assessments warned that releasing certain materials could create misinterpretations, damaging to public confidence. That phrase appeared more than once. The concern was not justice being compromised, it was perception. And so the calculus shifted. Transparency became a liability. Silence became policy. Victims noticed first. Requests for updates were met with form letters. Civil claims stalled as discovery requests hit walls of redaction. Some were told their cases were under review years after intake. Others were told nothing at all. Time passed, records aged, memories blurred. What remained consistent was the mismatch between scale and response, a case file count in the thousands, an accountability count near zero. At that point, the question was no longer whether mistakes had been made, it was whether the system had made a choice to contain the damage rather than confront it, and whether that choice would ever be subject to the same scrutiny applied to everyone else. That scrutiny never arrived through the courts, not because judges refused it, but because the cases that would have forced disclosure were never allowed to reach them. Prosecutors declined to file. Grand jury pathways were discussed, then abandoned. Without an active docket, there was nothing for a court to compel and nothing for a judge to unseal. In internal correspondence, senior attorneys acknowledged the risk explicitly. Once a matter entered a federal courtroom, discovery rules would apply. Evidence would have to be logged, shared, and explained. Decisions made years earlier, why certain leads were not followed, why certain names were segregated, why certain files went dark, would become part of a public record. That prospect carried institutional consequences, so the gate was never opened. Instead, officials leaned on procedural closure. Cases were marked inactive without being resolved. Others were folded into broader reviews that produced no individualized outcomes. The language was careful. No further action at this time. Pending resource allocation. Outside prosecutorial scope. Each phrase ended movement without admitting finality. Meanwhile, contradictions accumulated. Public statements emphasized cooperation between agencies. Internal logs showed requests left unanswered. Officials testified that evidence had been preserved. Inventory reports showed gaps. Leaders claimed victim protection as the rationale for secrecy. Yet victims themselves reported being excluded from information about their own cases. At one point, a briefing memo circulated warning that partial disclosures could lead to misguided speculation involving prominent figures. The memo did not deny overlap between evidence and public officials. It focused instead on reputational harm. The priority was clear, even if it was never stated outright. When journalists later requested aggregate data, how many files existed, how many had been reviewed, how many remained sealed, the responses varied by department. No single answer aligned with another. One office cited hundreds. Another acknowledged more than 1,000. None reconciled the difference. That inconsistency mattered. Because inconsistency is not just a bureaucratic flaw. In federal practice, it is often a signal that information is being compartmentalized to prevent a unified narrative from forming. Each office knew a portion, No office was positioned to speak for the whole, and so responsibility diffused upward and outward at the same time. No single decision-maker could be identified. No signature closed the door. The outcome emerged collectively through delay, silence, and procedural erosion. What remained was a record heavy with implication and light on accountability, a record where the scale of harm was documented internally but minimized externally, where evidence existed but access did not, where the absence of prosecutions was framed as restraint rather than omission. For any observer reviewing the file trail, one conclusion became harder to avoid. The system had not failed in chaos. It had functioned in order, an order designed to ensure that certain questions were never formally asked, because once asked, they could no longer be controlled. That control extended beyond files and filings. It reached language itself. When officials spoke publicly, the vocabulary narrowed. Allegations replaced accounts. Historical conduct replaced timelines. Complex jurisdictional issues replaced the simpler truth that no one had taken ownership. Each substitution softened impact while preserving plausible deniability. Inside the system, however, the language was different. Internal notes described repeat exposure patterns. Intake summaries referenced network familiarity. Analysts flagged non-random associations among individuals who appeared across witness statements without ever being formally linked in public documents. Those phrases never appeared outside restricted channels. One analyst questioned the discrepancy directly. Why, they asked? Did internal assessments acknowledge patterns that external communications denied even existed? The response did not challenge the analysis. It redirected the purpose. The goal, the analyst was told, was not to draw conclusions, but to manage material responsibly. Responsibly for whom? As time passed, external pressure grew. Civil litigation forced limited disclosures. Journalists obtained partial records. Names surfaced that had once been considered untouchable. Each release was described as unprecedented, even though the material had been sitting in federal custody for years. Still, the most consequential records remained sealed. Requests to unseal were opposed on technical grounds: privacy, national interest, ongoing review. Courts were told that disclosure could compromise future action despite no indication that future action was planned. Judges deferred. Deference became delay. Delay became permanence. Within oversight circles, frustration hardened into suspicion. Some members began asking not about Epstein himself, but about institutional conduct afterward. Who decided to restrict access? Who approved reclassification? Who determined that exposure risk outweighed transparency? Those questions pointed inward toward agencies charged with enforcing the law rather than evading it. Yet even then, testimony stayed careful. Officials spoke of collective processes, of interagency coordination, of inherited decisions. Accountability dissolved into abstraction. The cumulative effect was unmistakable. A case defined by secrecy did not end with secrecy. It expanded it. Each layer added after Epstein's death served less to protect an investigation than to protect the architecture that had failed to pursue one when it mattered. At that stage, the issue was no longer historical misconduct. It was contemporary governance. Whether federal institutions could investigate power without accommodating it. Whether oversight meant review or merely acknowledgement. Whether the absence of charges reflected evidentiary limits or a boundary the system had quietly agreed not to cross. Those questions remain embedded in the files that have yet to be unsealed, in the redactions that still block continuity, and in the silence of those who knew enough to recognize the pattern but not enough, apparently, to stop it. What made the pattern harder to dismiss was not what was revealed, but what never moved. Even after public disclosures reignited interest, internal posture did not change. No task force was formed. No independent counsel was appointed to review post-intake handling. The same offices that had overseen the stagnation were tasked with explaining it. Oversight without separation became oversight in name only. Records show that after Epstein's death, multiple agencies conducted what they called retrospective assessments. These were not investigations. They carried no subpoena power. Witness interviews were voluntary. Findings were advisory. The mandate was limited to process review, not accountability. In effect, the system audited itself. Predictably, those assessments concluded that procedures had been followed within the discretion afforded. Discretion, again, did the work. It absorbed failures and returned them as judgment calls. But discretion leaves fingerprints. Metadata logs revealed access to restricted files during periods when no active review was underway. Certain records were opened, then closed without annotation. Others were copied into derivative folders whose destinations were never documented. When asked why, officials cited routine administrative handling, yet routine handling does not usually require silence. Meanwhile, victims' counsel identified discrepancies between what clients had submitted and what appeared in federal summaries. Statements truncated, context removed. In some cases, entire encounters reduced to a single sentence that stripped chronology and detail. That compression had consequences. It changed how patterns appeared or failed to appear when cases were evaluated collectively. This was not fabrication, it was filtration. At the political level, distance increased. Officials who had once been asked directly about the case began referring inquiries to spokespeople. Spokespeople referred them to prior statements. Prior statements referenced ongoing review. The loop closed without resolution. What never happened was a full accounting of who knew what and when they knew it. There was no timeline reconstruction, no decision matrix, no explanation for why early warnings did not trigger broader inquiry or why later evidence failed to reopen doors that had already been closed. And so the file grew heavier without becoming clearer. For jurors reviewing this record, hypothetical or otherwise, the issue is not speculation, it is absence. The absence of escalation, the absence of documentation where documentation should exist, the absence of urgency in the face of scale. Institutions are often judged not by their stated principles, but by the moments when those principles demand discomfort. In this case, discomfort was managed, risk was contained, and the consequences of restraint were not borne by the system that chose it, but by those whose names remained behind redactions, waiting for a transparency that never arrived. That waiting produced its own evidence. As years passed, statutes of limitation closed quietly, one by one. Each closure reduced legal exposure without requiring a single affirmative decision. No memo needed to be signed, no refusal issued. Time did the work. In federal systems, time is not neutral. It advantages those already shielded by delay. Internal calendars reflected that awareness. In at least one planning document, attorneys noted upcoming statutory deadlines alongside recommendations to deprioritize pending review. The justification cited workload. The effect was predictable. Once the clock expired, questions about why a case had not moved forward became moot. At the same time, coordination with foreign jurisdictions slowed. Mutual legal assistance requests were drafted, revised, then left unsent. Some were transmitted after significant delay, arriving too late for meaningful action. When foreign partners asked why timelines had slipped, the answers pointed back to domestic review. Review that, again, produced no action. The courts were never given the opportunity to weigh in. Judges cannot compel cases that are never filed. They cannot order disclosure of evidence that prosecutors decline to introduce. The judiciary remained largely absent, not by choice, but by design of process. That absence was later cited as validation. Officials told oversight bodies that no court had found misconduct in the handling of the case. The statement was accurate and misleading. Courts had not ruled because courts had not been engaged. The distinction went unacknowledged. What did emerge slowly was a defensive posture. Communication strategies were developed to respond to renewed public interest. Talking points emphasized finality. This matter has been reviewed. No further action is warranted. The language was absolute, even though the record was anything but. Behind those statements sat unresolved contradictions, victim counts that varied by hundreds, evidence inventories that could not be reconciled, decisions attributed to collective judgment without identifying participants. The architecture of non-decision remained intact. For institutions built on precedent, that architecture set one. It demonstrated that when exposure risk intersects with power, process can be used not to advance accountability, but to exhaust it, not through overt obstruction, but through restraint calibrated so carefully that it appears from the outside as professionalism. The remaining question is not whether this approach was intentional in every instance. It is whether, taken as a whole, the system recognized the implications of its choices and accepted them. Because at some point, silence stops being neutral. It becomes a position. And once that position is established, reversing it requires more than disclosure. It requires confronting why disclosure was resisted in the first place. That confrontation never occurred internally. Instead, a different mechanism took hold: normalization. What once would have triggered alarm became routine. Redactions expanded without explanation. Delays were accepted as inherent complexity. The absence of indictments was framed as evidence of restraint rather than a question demanding proof. Over time, the extraordinary was treated as administrative. Internal briefings began to reference the case as a legacy matter. That term carried weight. Legacy implied inheritance, not responsibility. It suggested that current officials were merely stewards of decisions made before them, even as they continued to renew those decisions through inaction. When asked whether prior judgments could be revisited, officials cited continuity concerns. Reopening reviews, they said, could undermine confidence in institutional stability. The irony went unaddressed. Confidence had already been eroded, not by review, but by its absence. Documents show that some staff attempted escalation. Draft memoranda proposed independent review structures. Others suggested external oversight insulated from agency hierarchy. Those proposals stalled at intermediate levels. No formal rejection was issued. They were simply never advanced. That pattern repeated across divisions. Initiative met inertia. Questions met procedural deflection. The system did not say no. It said nothing. Outside the agencies, public understanding fractured. Partial releases fueled speculation. Incomplete disclosures encouraged rumor. Officials later cited that environment as justification for continued secrecy, arguing that misinformation risk required careful control of narrative. Yet the misinformation had grown in the vacuum left by official silence. This circular logic became self-sustaining. Withholding bred distrust. Distrust justified further withholding. Meanwhile, evidence aged. Digital formats changed. Custodial responsibility shifted with retirements and reassignments. Institutional memory thinned. Each transition increased the likelihood that gaps would be attributed to time rather than choice. But time does not erase metadata. It does not remove access logs. It does not explain why certain materials were viewed repeatedly without corresponding action. Those traces remain embedded in systems designed to preserve accountability even when decisions are deferred. For anyone reviewing those traces, the implication is difficult to ignore. The outcome was not the product of a single directive or a single actor. It was the result of alignment across offices, across years, around a shared priority: limit exposure, preserve institutional control, and allow the matter to recede without forcing a reckoning. That alignment did not require conspiracy. It required only agreement on what not to do. And as long as that agreement holds, unexamined and unchallenged, the files remain less a record of past misconduct than a living document of how power responds when accountability threatens to move beyond its control. That control began to show strain when fragments escaped the containment structure, not through official release, but through inconsistency. A document cited in one proceeding failed to match its counterpart in another. A date shifted. A reference number pointed to a file that no longer existed in the system where it was said to reside. These were not leaks. They were seams. When pressed about the discrepancies, officials attributed them to versioning errors, draft versus final, preliminary versus verified. Yet versioning normally leaves trails. Here, the earlier versions could not be produced. They had either been overwritten or reclassified beyond reach. At the same time, whistleblower channels recorded an increase in internal complaints, not about the underlying conduct, but about record integrity. Staff questioned why certain materials were exempt from standard retention schedules, why destruction logs were incomplete, why requests to preserve data were acknowledged but not implemented uniformly. None of those complaints alleged criminal intent. They alleged risk to cases, risk to credibility, risk to the principle that evidence custody must be defensible, especially when outcomes are contested. The response was procedural: training updates, policy reminders, no inquiry into whether prior handling met those policies. The future was addressed. The past was left untouched. As more civil litigation moved forward, courts began encountering the consequences. Judges noted gaps in discovery. Parties stipulated around missing records. Settlements resolved claims without establishing factual baselines. The legal system absorbed the absence rather than correcting it. In one exchange, a judge asked whether certain federal materials existed at all. Counsel could not confirm. They could only state that if such materials existed, they were not available for production. The distinction mattered, but it did not restore what was missing. Behind these moments sat a deeper implication. Evidence that cannot be located cannot be evaluated. Decisions that are undocumented cannot be reviewed. Accountability mechanisms depend on traceability. Once that chain breaks, oversight becomes speculative. That fragility did not go unnoticed within the system. Internal risk assessments warned that future disclosures, if compelled, could reveal process weaknesses difficult to contextualize. The language was careful. It did not describe wrongdoing. It described vulnerability, and vulnerability in institutional terms triggers defense. So efforts shifted again, this time toward narrative consolidation. Statements were aligned, talking points standardized, references to victim counts were narrowed to ranges, photographic evidence was described abstractly without specificity. Each adjustment reduced the surface area for contradiction, but consolidation cannot repair absence. It can only mask it. The files now tell a story not just through what they contain, but through what they lack, through decisions that leave no record, through actions taken without explanation, through the quiet acceptance that some questions, once deferred long enough, may never be answerable at all. And that raises the final unresolved issue still embedded in this record: whether a system designed to preserve justice can continue to function when preservation itself becomes selective, and whether anyone inside that system is prepared to account for the moment when selectivity replaced pursuit. What remains now is not a revelation, but a narrowing corridor. Because buried beneath the redactions, beneath the missing inventories and stalled reviews, there is one unresolved administrative fact that has never been publicly reconciled: a routing decision. A moment when custody of certain materials changed hands, quietly, internally, without a corresponding authorization trace that can be produced today. The handoff is referenced, the recipient is implied, but the approval record is absent. In federal systems, that absence is not incidental. Transfers of sensitive evidentiary material are logged precisely because they define responsibility. Once custody moves, so does accountability. And yet, when oversight staff later attempted to reconstruct that chain, they encountered a dead zone: no timestamp, no sign-off, no contemporaneous explanation, only after-the-fact rationales. Those rationales came from multiple offices, each asserting that responsibility lay elsewhere. One pointed upward, another outward. A third cited legacy handling predating current leadership. The explanations did not conflict outright, but they never intersected. Like parallel lines, they avoided a single point of convergence where accountability could attach. This matters because the materials involved were not peripheral. They were among the most sensitive in the record, the kind of evidence that, once formally acknowledged in the wrong forum, could no longer be contained by discretion or delay, the kind that forces institutions to choose between exposure and protection. At least one internal reviewer flagged the handoff as procedurally anomalous. That phrase appears in a margin note, never elevated. No follow-up memo, no corrective action. The anomaly was recorded and then allowed to stand. Since then, every inquiry has stopped just short of that moment. Oversight questions circled around it. Litigation brushed against it. Journalists sensed it without seeing it. The system collectively treated the gap as radioactive. And now, years later, with statutes closed and memories faded, the gap has taken on a different character. It is no longer just a missing record. It is a fault line. Because if that transfer was improper, the implications extend beyond a single case. They reach into how evidence involving power is managed, who decides when material becomes too sensitive for standard process, and whether there exists anywhere within the federal architecture a point at which discretion ends and obligation begins. Those questions remain unanswered, not because they were resolved, but because the record needed to resolve them is incomplete. What is known is this: somewhere between intake and inaction, a decision was made that altered the trajectory of everything that followed. A decision that did not require a vote, did not require a court, did not require public notice, only silence. And until that silence is explained, until that handoff is accounted for, the file is not closed. It is waiting.